The broadcast is now starting. All attendees are in listen-only mode.
A warm welcome to this UK IBC webinar in partnership with one of our members, Trilegal. Today we're going to be looking at India and its unlocking and how that's going to happen, and of course what are the legal obligations on businesses as they start to unlock. My name's Chris Hayes. I'm one of the directors here at UK IBC. As always, I hope you and your families are all safe and well during this difficult period. As you may have heard from our previous webinars, this is one of a series that we have undertaken to ensure our networks are kept up to date with key matters. Our next event, which is happening next week on the 23rd of June, will look at India post-COVID-19 and will feature a great lineup including HSBC, PwC, and one of the law firms here in London, Freshfields. Feel free to sign up for this on our website, where you can also find recordings of our previous events in case you've missed them. To keep up to date with all of our events and developments, feel free to follow us on Twitter. You can see on the screen our Twitter handle at UKIBC. Also feel free to follow Trilegal at Trilegal Law. You can follow us both on LinkedIn, just simply search our names. And of course, you can sign up for the UK IBC newsletter on our website to receive regular updates. Before we start, some housekeeping. You will automatically be placed on mute for the entire session. However, you will notice in the top right-hand corner, there is a question box, which you can use at any time during the presentations to feed the questions through to me, which I can then put to Atul at the end of the session. You will also be glad to know that we are recording this session, which will be placed on our website afterwards, and the link emailed to you all in case there are any sections that you would like to re-listen to, or if you wish to share that with your colleagues or your network. So to unlock or not to unlock, that is the question, as they say. It is certainly the question facing governments all over the world at present. In the UK, non-essential shops opened yesterday with large queues outside some shops as strict social distancing measures were put in place. Face coverings are now mandatory on public transport in the UK, and the 2-metre social distancing measure is now officially under review. In India, it announced its Unlock 1.0 on the 8th of June after 2 months of lockdown. And whilst the national government set guidelines for unlocking, it is up to individual states to tailor these for their own regions. Movement of people between 9 PM and 5 AM is forbidden. And unfortunately, it's very likely that today India will surpass 10,000 deaths in their journey, given the current trajectory. And obviously our thoughts and prayers are with not just those 10,000 people, but all of the people who've lost their lives all over the world. Currently, India is under its 5th phase of lockdown, otherwise known as Unlock 1.0, and it entails much more relaxations than the previous ones, including rail, road, domestic air travel. However, the relaxations do not apply for containment zones, which have to follow strict guidelines issued by the Ministry of Home Affairs, and that is updated from time to time. The difficult question facing the UK and Indian governments, and indeed governments all over the world now, is lives or livelihoods. To help us through this difficult and ever-changing landscape, we have Atul Gupta, a senior partner at Trilegal, working on the employment practice, which he helped to establish and now leads. Atul is regarded as one of the leading authorities and thought leaders on Indian labour and employment laws. His views on key developments have featured in national newspapers and are sought after by many major industries and trade bodies. So obviously at UK IBC, we are delighted to have him for this webinar. Atul focuses his practice on advising clients on high-stake employment law issues, both of contentious and non-contentious side, including senior management terminations, large-scale reductions in workforce, establishment closures, M&A, outsourcing, insourcing, employment disputes and litigation, as well as investigations and inquiries arising from employee misconduct or white-collar crime. Atul, really delighted to have you here and really looking forward to your presentation. So it's over to you.
Hello, everyone.
Hi, Atul. Thanks for that.
Thank you for that introduction, Chris. Appreciate it. A very good morning, good afternoon, good evening, wherever you may be, to all the attendees. I hope to spend this afternoon in India talking through some of the key employment law concerns that organizations now need to focus on as they move into Unlock 1.0 and start, reopening their workplaces. We are going to talk about, a couple of key subjects today. Firstly, being what are mandatory versus advisable workplace protocols on social distancing and safety. How do we deal with vulnerable employees as part of that? Dealing with continued absence of employees who might hesitate to come back into the workplace on account of various fears or trepidations associated with the spread of the virus. Are there any special leave entitlements for employees who might contract COVID-19? As well as the biggest issue that a lot of organizations and our clients keep wondering about is what liability do organizations have if any of their employees do contract COVID-19, right? So that's the agenda for this afternoon. And I would, of course, like to start by saying that this is a ever-developing field, and regulations are being created on a routine basis, both at the central government level and at various state government levels. To that extent, the conversation today is not going to go into state-specific rules. We will talk about this slightly at a higher level based on, guidelines issued by the central government as well as the Ministry of Health and Welfare. Although I'd be happy to separately address any questions or queries that people might have based on their specific locations. So let's start by taking a quick look at what the statistics were as of yesterday. Some states are thankfully faring better. I'm based in Bangalore, in Karnataka, where the confirmed cases and the number of deaths is significantly lower compared to some of our neighbors and other states in the country. Maharashtra leads the pack, unfortunately, with a large number of cases and deaths. Tamil Nadu is another state where the number of cases have been rising quite significantly. In fact, the Tamil Nadu government just yesterday ordered a fresh lockdown ranging from 19th to the 30th of June in 4 key districts in Tamil Nadu. So as we can see, there is a necessity to be completely observant of what the government is doing and stipulating in every jurisdiction where you might have operations. And you would need to keep a robust plan of action in place, which caters to these potential changes in policy from time to time. We are currently, in fact, advising organizations in various states deal with potential closures that they are facing on account of an increasing number of cases in those jurisdictions, or potentially on account of increasing number of cases of COVID-19 infected employees in their own specific establishments. For the benefit of those who might be joining in or tuning in from outside, a quick glance at the measures adopted by the government. As is the case globally, in fact, in India too, the authorities wield wide powers, both at the central and the state level, to contain the spread of the virus. Authorities have been invoked under the National Disaster Management Act and the Epidemic Diseases Act to put into place various stringent measures. We are now seeing individual establishment closures being ordered in many jurisdictions. because of the fact that there is a large number of cases in those establishments. The COVID-19 regulations that were originally rolled out in March at the very beginning, in fact, allow governments to seal complete geographic areas, ban vehicular movements, close offices, schools, etc., and designate any building as a containment unit, in addition to imposing quarantine and isolation forcefully. Most states have ordered temporary closure of public places, malls, cinemas, gyms, bars, tourist spots, even right now. There has been some relaxation since the 8th of June, but it is still not at the same level that existed in the pre-lockdown levels. Public transport has resumed in a lot of different states with limited capacities, which in a sense has also contributed to a greater number of cases that are now arising. But as far as organizations are concerned, I think it's important to put into place certain other measures and precautions in place, which we will deal with in our subsequent slides. So the first thing that organizations need to be very cautious about are what are mandatory versus advisable workplace protocols, right? The government has come out with its Unlock 1.2 notification, which in the annexure contains certain measures. A lot of organizations have been confused around some measures as to whether they are mandatory or directory in nature, because the government has also flip-flopped a bit on those. If you were to compare prior and more recent orders, the Ministry of Health and Welfare has come out with protocols as well from time to time, which were issued in May, then recently updated in June. So how do we navigate all of these various orders and protocols and advisories to sort of chart down a list of what are absolute musts when it comes to reopening the workplace versus things which may not be absolutely mandatory but are still nonetheless advisable? So a lot of this content has in fact been picked up from the website of the Ministry of Health and Welfare, which is a great resource for organizations to tap into. Let's first look at the mandatory protocols. A lot of organizations ask us questions, is it right for us to screen employees, measure their temperatures, may have to potentially store it, report it? Are there any privacy concerns associated with it? Are we in the right by seeking such kind of information which is potentially sensitive or medical? Well, the answer is that thermal screening is now mandatory under the workplace protocols. So all entrants, visitors, staff have to be mandatorily thermally screened while they are entering your premises. In fact, the protocols require organizations to mandatorily inform medical facilities or call the local helpline or authorities if anyone is reporting into work with potential fever or other symptoms which might point to a potential COVID infection. So these are in fact mandatory requirements that organizations cannot bypass. Apart from doing thermal screening of all visitors and employees, organizations also need to put into place staggering requirements so that not all your workforce is reporting into work at the same time, because that would make it very difficult for organizations to maintain social distancing. So staggering of workplace and timings is something which organizations need to certainly do. In fact, visitors should be limited to the absolutely essential ones, so that there isn't any influx of random people coming to your establishment. The protocols, in fact, require organizations to discontinue, standard visitor passes and only allow visitors on a absolutely needs basis to ensure that the potential spread of the virus is limited. Now, one of the questions that gets asked is, what is adequate social distancing? The Ministry of Health and Welfare in its protocols issued in May had in fact said that 1 meter social distancing is required in the workplace. the more recently issued protocols issued by the MOHW do not specifically call out 1 meter as far as the space between seats are concerned, right? It simply states that organizations should maintain adequate gap in seating arrangements. So that's something which organizations will have a little bit of flexibility around. Although it must be noted that the protocols also talk about a minimum of 6 feet gap, which we will come to when it comes to public places within the establishment, as well as it stipulates specific distance parameters which are advisable when it comes to places like cafeterias, etc., within your workplace. A 1 meter prescription has been prescribed there. So, when it comes to the question of what is the space that I should maintain as far as seating arrangements go in my establishment, organizations would be best advised to follow at least the bare minimum international protocols issued by the World Health Organization. The 6 feet or the 6 gaz ki duri, as it's touted by the government, is more of a distance that is applicable for purely public places. Workplaces may have a little bit of flexibility associated with that, but we would still strongly recommend maintaining a minimum of 1 meter's gap, and if not more, between workstations and working seats. Other mandatory workplace protocols include having mandatory sanitizers and dispensers at the entrance and at various places in the establishment. Strictly speaking, only asymptomatic staff visitors should be allowed within the establishment. A lot of organizations are relying on technological solutions to try and get this data even before people can end up at your gates, so that you don't have to turn them back. Masks has become mandatory, and it appears that the protocols are strict enough to expect all organizations to make the use of masks mandatory at all times. Of course, there might be case-to-case deviations. For example, if someone is sitting in a closed cubicle, while they are within that confined space, maybe a mask might not be necessary. But at the same time, the protocols also recommend good respiratory etiquette. So if employees can be required to keep masks on at all times, that would be absolutely advisable and necessary, in fact. Other than absolutely limited exceptions where someone might be, sitting in their own cubicle and not be exposing themselves to other people within the organization. Organizations have to maintain minimum requirements in terms of, air conditioning, a minimum of 24 to 30 degrees centigrade and relative humidity of 40 to 70%. There has to be posters and other information put out mandatorily explaining to individuals and employees what measures are necessary and have to be followed at all times, so that people are constantly reminded. Shop stalls, cafeterias within establishments, and this is for larger organizations with larger campuses, should follow social distancing within and outside their premises. So the fact that you might be within a let's say a closed campus wouldn't mean that there is relaxation on how people can approach these establishments within the campus. Effective and frequent sanitization is absolutely mandatory. Frequently touched surfaces have to be regularly cleaned and disinfected using 1% sodium hypochlorite solutions. Apart from using face masks, their safe disposal is also absolutely critical. Other mandatory workplace protocols include things like proper crowd management in parking lots, If you've got staff or drivers residing in containment zones, they should not be allowed to drive your vehicles. Anyone, in fact, in that for that matter, living in a containment zone should not be allowed to come to work. And organizations would therefore have a duty to continuously monitor what containment zones are being declared by local governments. Organizations are expected to maintain separate entries and exits for officers, staffs, and visitors so that there is no intermingling and risk of the contagion spreading through outsiders. In some establishments where valet parking is operational, disinfection is necessary of vehicles, touch points like door handles, keys, etc. Elevators in multi-story buildings have to have limited number of people. Again, no specific numbers have been quoted to say that an elevator can have only 2 people or 3, but we would strongly recommend maintaining at least a 1 to 1.5 meter distance between people in elevators as well. Now, what happens if there are reported cases within your establishment? The government clearly acknowledges that that is a possibility. And to that extent, if there are only 1 or 2 reported cases, then the area where those employees were working or visited should be disinfected, and there is no need to close down the entire office and grind your operations to a halt. Those specific areas can be disinfected and closed for 48 hours. But if there is a larger outbreak, right, and if there is a potential that your office is turning into a emerging cluster, then there is potentially a necessity for you to close down the entire building or a block for thorough disinfection. Employees should be required to work from home until they are, the office is fit for reoccupation. And unlike in other countries like the UK, where I understand that organizations have to carry out a risk assessment before they open up their workplaces. Over here, there is no similar requirement, but if there are reported cases of COVID in your workplace, then the authorities will conduct a risk assessment and determine if any special measures need to be put into place. For example, if individuals need to be asked to isolate or put into mandatory quarantine, including contact tracing, so on and so forth, right? So the government then steps in to take stock of the situation, how many people are infected, what the potential source is, and directs organizations as to next measures. We are seeing increasingly cases arise where, because of a larger number of cases that have arisen, organizations have been ordered to close until further notice, so that disinfection can be carried out. In such situations, organizations would be strongly advised to also advise their employees to maintain self-isolation and avoid unnecessary travel, so that the potential of the organization reopening and finding again that people are infected because of disease that they may have acquired through outside sources doesn't result in increased disruption again for the organization. Now, moving on to what might be advisable workplace protocols. The biggest question we get asked is about the Arogya Setu app. Right? Originally, the government said that, listen, this is mandatory in nature. Everyone has to follow it. Everyone has to ensure that this is installed. The head of the organization was vested with that responsibility. There has been a softening of that stance. The MHFW guidelines are a bit vague. They simply say the Arogya Setu app should be installed and used. But going by what the government's previous orders were, it's now on a best effort basis. So organizations would be expected to ask employees to download and use that app on compatible devices. And we would advise organizations to check the status of the employees before they come into the workplace every day. We also, in fact, advise organizations, and while this is not explicitly laid out in the protocols, to actually get written declarations from employees as to whether they have moved or traveled to at-risk locations or come into contact with anyone who is potentially at risk or has been declared positive, and also to declare their health status on a regular basis. Now, I dealt with the question of the distance that has to be maintained in the workplace. 6 feet distance should be maintained wherever possible. 1 meter distance has been again prescribed in the cafeteria if feasible. We think that these are strongly advisable, and deviations should really not be made unless absolutely unavoidable. Things like video conferencing for meetings, staggering of office hours, lunch hours, coffee breaks are all strongly advisable workplace protocols. In addition to, advising employees to frequently wash their hands, use sanitizers, and provide the same. Right now, one of the other issues that gets asked is how do we deal with vulnerable employees, right? The general guidance is that people who are ages of about the age of 65 years, children less than 10 years, pregnant women, and persons with comorbidities should stay at home. Now, obviously, the first two categories might not be too relevant for organizations. That's post-retirement age for most people, and children are anyway out of the question. But when it comes to pregnant women and persons with comorbidities, organizations are grappling very often because they are getting asked inputs from employees saying that, I have diabetes, or I have hypertension, or I have some other ailments. So how do you expect us to report to work, or what are the measures or protocols you're putting into place? I would strongly recommend taking a cautionary approach towards vulnerable employees. And this is also to some extent linked with the liability provisions that we'll talk about later, where in case of a death of an employee, the exposure is potentially higher, both under the Employees Compensation Act as well as the NDMA Act. But at the same time, it's not an absolute must. So organizations would be advised to take cautionary but commercial decisions in terms of whom they allow into the workplace. If there are indeed employees who can be permitted to work from home because they have comorbidities, then that should be enabled, even if it might entail a little bit of a cost or an expenditure or some form of adjustment that the establishment has to make. The general default position should be that employees who have some vulnerabilities should not be placed in a position of risk. If it's completely unavoidable, for example, you are running a establishment like a factory which needs people to work only at the workplace, and the jobs can't be done remotely, it's not illegal to require such people to come in. But you need to put in a fair bit of effort to ensure that they are not exposed to the public at large. Their strict social distancing and sanitization measures are put into place so that the risk of them contracting the virus are low. This would also include things like providing secure transport facilities so that people don't have to rely on public transport, where the risk of contracting the virus is much higher. Now, the question we get asked is, what do we do about employees who are simply refusing to turn up to work? Right now, the overall government guidelines is that the work from home should be allowed if it is feasible. To that extent, organizations should put in some clear thought on what functions can be allowed to perform remotely. And where the function is not capable of being performed remotely, and the employee is refusing or is absent from work, right? You would need to examine this based on merits. So first and foremost, you would need to discuss with the employee whether there are any alternative arrangements. For example, is there an alternate job profile that they can fit into that can be performed remotely, or is there any other function that potentially fits their works and experience that they could perform remotely? If not, if there is no such alternative, or if they do not agree to such alternative and their job cannot be performed remotely, in such a situation, employees could potentially be asked to take leave, either banking on their accrued leave balances or on unpaid leave. The position of the government has been straightforward, that with the unlocking of the economy and the opening up of the workplaces, employers and employees would both have to work with each other to try and reopen the workplace. Employers, of course, have the obligation to ensure a safe and secure work environment. And to the extent that you can demonstrate that that has been done, it then might not be possible for employees to completely reject the possibility of coming into the workplace, right? Unless and until they have legitimate grounds, for example, vulnerable employees that we talked about earlier, where employees are simply raising fears that, I'm afraid, my family is afraid, and, I just want to stay put. Then potentially those aren't strong enough or compelling reasons to allow them to not turn up to the workplace. And then they might be the classic group of employees who you would place on paid leave or on unpaid leave. Theoretically, you could also discipline such employees, but we would not really recommend going down that path. It would also be important to note that the Mumbai High Court has ordered, and this is via an order dated 30th April, that if employees remain voluntarily absent, then the management is at liberty to deduct their wages for such absence. So that gives organizations the ability to, in good faith, expect employees to come into the work, taking into account, of course, vulnerabilities that we discussed. And if employees are still refusing, then you could you wouldn't be necessarily compelled to continue to pay them fully, assuming you've put into place absolutely clear and transparent measures to ensure workplace safety. We strongly recommend organizations roll out standard operating protocols, which are clearly documented and communicated to all employees. Ideally put up on your website, sent to everyone via email. And in addition to that, we would strongly recommend setting up a committee or a working group which is vested with the clear authority and responsibility to make sure that those protocols are being followed, reviewed, and updated as necessary, so that workplace health and safety is ensured at all points of times. And that can become absolutely critical, because with this continuing spread of the virus, the likelihood that people might contract COVID in your workplace is a very, very real possibility. And in such a situation, as organizations and employers, you don't want to be at a point or a juncture where authorities or employees could accuse you of not taking adequate measures or not communicating clearly enough what protocols are in place and enforcing them strongly and strictly. As I was mentioning earlier, if there are suspect cases or confirmed cases in your establishment, you need to immediately inform the nearest medical facility or call the state or district helpline. If they do turn up to work and you screen them at the entrance and you figure that they are potentially symptomatic, you need to certainly immediately move them to an isolated room or area or a containment zone within your own establishment, and allow the authorities to carry out a risk assessment, so that you can be guided as to whether the establishment needs to be shut or a particular area needs to be cordoned off, etc., for disinfection purposes. There aren't currently any special leave requirements for infected employees. That's a question that we are getting asked again. Employee has contracted COVID. Now what do we do? There's clearly not capable of attending work, depending on the severity of their virus, from anywhere between a couple of days to a couple of weeks. At present, there are no special extra sick leave requirements at the central level. Some state governments like Karnataka, Uttar Pradesh, and Tamil Nadu have prescribed additional leave that organizations will be mandatorily required to give to infected employees. And if you have low paid employees who are covered by the ESI Act, then they might be able to get benefits under that statute. Now, coming to the very end, the question of liability, which is paramount on a lot of organizations' minds. We get asked whether the Employees Compensation Act would apply. Now, in strict terms, the Employees Compensation Act does apply to commercial establishments in practically all Indian states. Local Shops Act or other amendments have ensured that commercial establishments are also covered by the Employees Compensation Act. However, it is still a gray area given the very widespread of this virus, and how it's going to be so difficult to actually identify with any amount of certainty as to where someone contracted a virus, whether it was potentially during a private activity, such as, for example, going out for a grocery run, or whether it was on company transport or while coming to the workplace, or at the very workplace itself, right? Given the widespread of the virus, now it could, in certain situations, become difficult to identify, especially in locations where the number of cases are now in multiple thousands, right? So to that extent, there isn't any established precedent right now as to how such claims will be dealt with under the Employees Compensation Act. But a strict reading of the law would suggest that if someone can establish they've contracted the virus out of or in the course of employment, then they would be entitled to compensation under the Employees Compensation Act. It could be deemed to be a injury or an accident arising out of or in the course of employment. It's difficult at this point to say that this is an occupational disease. Certain functions, for example, your security guards, people who are screening visitors, the people who are sanitizing your workplace, for them it is clearly an occupational hazard now, because they are frontline workers and are exposed to the potential contagion. But those who aren't in these types of jobs, it might be harder for them to say that it's an occupational hazard. And for them, it becomes a more case-specific assessment as to whether they potentially contracted the virus during or in the course of employment. Indian courts have said in the past that if an employee is put in a position where they are exposed to a virus, and there is a Guwahati High Court ruling on this, then it would be covered in under the ambit of the Employees Compensation Act. The liability, if there is a successful claim, would potentially extend to providing sick leave with pay, covering the expenses for the treatment, which could be significant, especially if there is ICU admission and ventilator support required, and compensation if the person actually, unfortunately, expires. Keeping in mind this exposure, we strongly recommend organizations do one of the two, ideally both, which is get all employees covered under your corporate health plans if you're not already doing it, and also separately seek insurance cover for the establishment itself under the Employees Compensation Act. Practically every insurer offers insurance cover to establishments, which helps offset any exposure that they might face under the ECA. A statutory or a regulatory breach of any of these workplace protocols, mandatory requirements, health and safety measures could result in imprisonment and fines, both under the National Disaster Management Act as well as the Penal Code. The imprisonment can extend up to 2 years in case of death of an employee. And as we talked about earlier, there could also be exposure under laws like the Employees Compensation Act. The other risk that organizations need to be mindful of, especially keeping privacy considerations in mind, is if you are now going to be more regularly collecting and utilizing or saving medical information far more frequently than you would have historically, and if all of that is stored or saved in an electronic form, then the rules under the Information Technology Act that deal with the storage, use, transfer of sensitive personal information should be strictly followed. employee consent should be put into place. This information should not be shared or transmitted. And any sort of wrongful loss to an employee that might arise due to negligence on this part could result in liability under the Information Technology Act as well. So that is an additional aspect to bear in mind. So that sort of brings me to the end of what I had hoped to cover today. And if there are any questions, I'd be happy to answer those right now.
Well, Atul, a huge thank you for that. I think that was extremely informative. I think it's a very difficult and very challenging time for everybody, really. So to be able to understand what is not just your legal requirements, but also what is the best practice, I think is extremely important. There's a number of questions that are coming through, but just to remind you, if you do have any questions, please feel free. The question box in the top right-hand corner, please type those through and we'll get through as many as we can to Atul during the end of this session. Firstly, just a question from me, Atul. Given that you mentioned that obviously different states are allowed to tailor their own guidelines, how do businesses sort of understand what obviously is the issues in their state, or what is the guidelines, but also how can they plan effectively given that different states will have such different rules?
Yeah, Chris, that's a issue that a lot of organizations are grappling with. A lot of our MNC clients who have operations in, let's say, 7-8 different states, right, are essentially taking the approach to go with the safest possible protocol. Now, for example, we talked about whether 6 feet social distancing is mandatory within the workplace or not, right? The reading of these regulations suggests that that's not absolutely mandatory, except for public spaces within the office. But in some states like Gurgaon, the Unlock 1.0 order actually, if you read it carefully, suggests that 6 feet is mandatory even within the office. Now, to that extent, some organizations are just taking the stand that we go with the safest possible approach. There is undoubtedly a onus and responsibility on organizations to keep track of each state-specific requirement and tailor their policies if required locally. But if you're planning to roll out a standard operating protocol, which is sort of applicable on an entity level basis, we would recommend taking the approach which is the most conservative given the nature of the issue. And if local rules really allow for a relaxation or maybe a more stringent requirement, you could potentially have local administration tailor the requirements locally for that. But we would recommend avoiding that as much as possible to avoid confusions and lapses, if not anything else, while implementing these measures. But it's best to take a safer approach while you're rolling out something which is meant to apply uniformly across the country.
Cheers, thanks for that. We've got a question coming from Amy Mock. Could you tell us a little bit more about the recently announced mandatory medical insurance for employees?
So the medical insurance requirements are one of those which remains gray in terms of whether it's mandatory in every state or location or not. It was originally announced in April as a mandatory requirement, but subsequent orders have not really found a mention of that in some states. As I was mentioning earlier, from a liability standpoint, if someone does contract COVID at the workplace, there could be exposure on an organization to pick up their medical costs as well. That's explicitly laid out under the Employees Compensation Act. And to that extent, we would strongly recommend that organizations extend corporate insurance cover to employees. That's not life cover, it's purely medical against hospitalization. At least, I mean, even in the pre-COVID era, we saw that this was a fairly common thing for organizations to provide. at least in certain businesses and sectors, for example, the IT/ITES space and the service sector on the whole. Organizations are able to negotiate and offer such insurance on pretty low premium levels because they're buying in bulk with insurers. So even though it might not be mandatory in all Indian states, we strongly recommend and advise that a medical insurance cover be extended. I think the cost-benefit analysis would prove eventually towards purchase of such insurance as compared to picking up the cost associated with helping employees deal with the medical expenses if they do get infected, and we are really seeing an increasing number of such instances arise at the workplace as well. So it's not just in public spots or in clusters. We are seeing this arise actually in workplaces despite a lot of precautions being put into place.
Cheers, thanks. We've got another question here from Milland, and I guess this is one that will probably affect quite a lot of businesses. Is ECA applicable to staff on contract through vendors? So obviously people like reception staff, like housekeeping staff. So who is liable then? Is it the company that's contracting them, or is it the company they're providing the service within?
Yeah, so the ECA applies even to contract staff. It's an explicit provision under the law. The definition of employee is wide enough to cover contract staff as well. Section 12 of the ECA deals with the issue of who is responsible if a contract worker is able to claim compensation. And the simple reading of that law is that the principal employer, which would be your establishment, if you're engaging with a third-party agency, can be held liable to compensate the employee. However, the law also expressly acknowledges and recognizes the ability of the principal employer to be indemnified by the contractor for any compensation that it might be exposed to. To that extent, we always recommend, therefore, a two-step protection strategy. One is, of course, seeking insurance cover under the ECA for your establishment itself. Some insurance cover also extends to contract workers. That's typically an add-on to the standard cover. But if you don't opt for coverage of contract workers under your insurance policy, that's fine, because under the law, you have the right to be indemnified by the contractor. Now, you would need to make a commercial call based on which type of contractor you're dealing with as to what their financial wherewithal and capability is to pay you. But if you have a good vendor with strong financials, then potentially you can rely on the statutory provision to ensure that they pick up that liability eventually.
Okay, thanks. We've got a question here from Naveed. I'm going to link this into a question that I had actually as well. So Naveed asks, where should the government be informed if an employee turns COVID positive, state helpline or national helpline? And then from my side, sort of is there any sort of incentives for the businesses to do this? I mean, given that so many businesses are small and medium, and obviously will not want to shut down, as effectively they might go out of business. What is the imperative on them? Is it just merely sort of fines and a stick, or are there some sort of encouragements to help them through if they have to?
Sure. So the reporting should be done to the local administration, the local helplines and the healthcare department, so that because they are keeping a tab and on local dynamics of as to the spread of the virus, right? The biggest responsibility that the government now has, given that the workplaces are opening up, is to avoid cluster formations, and which means more than just 1 or 2 cases, maybe 15 or more cases, or could be viewed as clusters. And to that extent, I think it's there isn't really any benefit for an individual to report it. In fact, practically thinking, there is only a potential downside, because if indeed there is a large cluster that is forming, a large number of employees that are being infected, there is a very real possibility you might be asked to close for a certain period of time. But at the same time, if you fail to disclose, there is a very strong possibility that you could be prosecuted, right? What's important right now is for the state machinery to tie up and to connect where positive cases are potentially arising from. So it's a fact that if someone is actually tested positive, the government would know about it, because tests are being conducted by authorized labs, and those results are all being shared with the government. But what it might not really know, unless and until the employer has also intimated them, is whether the person who tested positive actually works in a particular establishment or not. And unless that reporting can come in, they will not be able to promptly and in adequate time identify potential cluster formations. And so a failure to report by the employer can actually have severe repercussions in trying to contain the virus. Because it might take much longer for the government by itself to connect why 20 different cases living in 20 different parts of the city are all potentially connected to one single establishment if the organization fails to do the reporting. So I think the reporting is essential. It certainly comes with the risk that you might have to close on a temporary or on a slightly longer period basis to help with disinfection, contact tracing, etc. But if you don't, then I see the potential risk to the organization as being much higher.
Cheers, thanks for that. Another question here from Trevor Bull. He's asking about how businesses can avoid issues. Say, for instance, they had sort of a member of staff that was about to be released on poor performance or other issues around governance, but they weren't able to do that because of the lockdown, and now that employee claiming that they are made redundant due to COVID-19. So how would you sort of recommend sort of around if those type of challenges came up?
Yeah, so I think that was one of the most burning questions on organizations' minds. Are there any limitations or restrictions from not paying wages or from terminating employees on account of the lockdown? I think the position is with each passing day getting a little bit more clear. A lot of the government orders and advisories have been challenged before the Supreme Court. And by that I mean orders and advisories which compelled organizations to continue to pay or which prohibited them from terminating anyone, right? These have been challenged before the Supreme Court, and the Supreme Court so far has continued to provide interim relief in the form of telling state and regulators not to take any coercive measures against employees. I think the situation that the person is asking about around legitimate performance issues, etc., are anyway at a lower risk. So if you were just making people redundant, that potentially is slightly larger risk compared to where there are genuine conduct issues, performance issues. I would say that if you followed the standard expected process, which is highlighted the performance issues, given them an opportunity to improve, of course, taking into account accommodations for the fact that they might be working remotely, etc., you would still be, it would be legitimate and fair to then ask these employees to go. I do not foresee a significant risk. And with the withdrawing of the 29 March order from 18th May, which made it mandatory for employers to pay in full all employees, the risk is even lower in the current circumstances. Most state government orders and advisories were also a reaction to the central government's orders and advisories, and given that those have been withdrawn, it's reasonable to infer that the state orders are also not binding and mandatory anymore. So if there is fair basis, then right now, at least in the current state that we are in, it would be okay to my mind to move forward with such exits, provided you've taken the necessary precautions and followed due process.
Cheers, thanks for that. I've got another question here from Nirupa. So she's asking a specific question about Karnataka and saying, do they still need to submit COVID-19 self-declarations on behalf of the companies? And if so, are they able to ask their employees to self-declare?
Yeah, so the SOPs that had been released by the Karnataka government earlier went into a lot of details, including asking employees to provide that self-declaration. There have been further orders subsequently. We believe that the detailed SOPs, to the extent that they have not been completely revised by subsequent orders, continue to apply. So I would say it's still advisable to seek those declarations by employers from employees as they come into work, and this is what I was also referring to earlier. It helps to do that because it's impossible with the opening up of the workplaces and economy to keep track of where people have been, whom they've been in contact with. Asymptomatic carriers are a big risk. So those declarations on a daily basis can go a long way in if not anything else, mitigating liability for the organization to show that you took due care and precautions before letting people in.
Yeah, and I guess linked to that, we've got another question that's come in around sort of evidence, really. You mentioned before, obviously, about having to make the calls to those national or state level telephone lines, obviously, to declare those positive cases. But what evidence can businesses keep on that? Because perhaps many of those lines might be inundated and might not actually record the information. So what would you suggest in terms of having sort of that evidence trail for the businesses?
Yeah, so the government has also provided email IDs in most locations. So we would also recommend, apart from just calling the helpline, is to providing an email update every day, or periodically, as and when you do recognize that someone has reported as symptomatic or tested positive, as secondary email evidence of the fact that you've complied.
Yeah. And the final question, really, you mentioned about sort of companies being liable if employees contract COVID-19 whilst at work, and sort of thinking that from the point of view of so many businesses now work in sort of co-working spaces. So how would that be sort of pushed through in terms of how can it be proven? Obviously, if you're in a co-working space.
Yeah, that's a challenge that is unique to co-working spaces. I think it would depend to a great extent as to how that place is designed. A lot of co-working spaces again are structured such that each business has its own independent access controlled space. So the co-working space owners will necessarily need to put into place all these SOPs for all their clientele and visitors, so that the co-working space itself can try and avoid liability. And organizations who are working out of those co-working spaces will need to put in a secondary layer of SOPs. And again, it depends in terms of what the size is. We've seen co-working spaces being used from a couple of seats to entire floors, right, that clients might take up. So depending on the amount of space you're taking up, depending amount of the footage you're occupying, you might need to put into place special measures on top of what the co-working space itself is doing. We've in fact had co-working space owners and in fact even landlords of buildings which rent out their premises to multiple clients. We have suggested and recommended to them that they get declarations from their clients and customers that they have put into place adequate safety precautions and protocols, which go, which to some extent might not be within the control of the person who's operating the co-working space. So, for example, for someone who's operating the co-working space, it might not be easy for them to see declarations from clients' employees as to where they've been or what they've done, or what their health status, etc. are. But it can at least ensure that the clients are doing that, so that they are protected. As far as visitors are concerned, the co-working space can put into place strict protocols to ensure that visitors are not allowed if they are showing any sort of symptoms, or if they declare anything which suggests that they might be at risk.
Fantastic. Just going to squeeze in one last question. Is there any notice on turning on the air conditioning system in offices? I know you sort of briefly mentioned that in the presentation.
So those are in band, but the temperature range should be maintained between 24 and 30 degrees, and humidity has to be maintained between 40 and 70 degrees. It can be impossible in a lot of modern offices to operate without the central cooling and HVAC systems functioning. And that's understandable. So the air conditioning system should certainly be put to use, but with the adequate precautions associated with the temperature monitoring. And of course, if you've only opened up your office after several months, then a thorough disinfection before they are put to use.
Perfect. Well, it's just down to me then to say a huge thank you, Atul, for your time. A huge thank you to Trilegal as well for supporting us on this webinar. Just a reminder, our webinar next week is looking at the COVID-19 and the Indian economy, what that looks like as we unlock further with Chief Economist from HSBC, PwC Senior Partner looking at particular sectors, and then also Freshfields Legal talking about sort of activity that might happen in the market or what they foresee will happen in the market. Finally, just a big thank you to everybody for tuning in to this UK IBC webinar, and a huge thank you. Please stay safe, and we look forward to seeing you again next week. Thank you very much.
Thank you, everyone.